Welcome back to another kick-ass vlog as part of my family court information and support service. And today I will be answering the question, who should prepare the family court bundle? I am Philip Kedge, a retired police chief inspector, the director of the McKenzie Friends UK network, and I have been a McKenzie Friend layperson for over a decade. Now, nothing I say constitutes legal advice because you don't need legal advice and you absolutely don't need family lawyers. So stop hiring them before you end up in crippling financial debt. Let's do it. The secret with any court order or other directions received from the court is to read them carefully and follow the instructions. When it comes to who should do the bundle, check whether it states a bundle is required and who should prepare it. If there aren't any instructions, then you don't need to worry. So let's take a look at the information and rules behind all of this, which can be found in what is known as Practice Directions 27A. Practice Directions 27A at paragraph 3.1 states, a bundle for the use of the court at the hearing shall be provided by the party in the position of applicant at the hearing, or if there are cross applications, by the party whose application was first in time, or if the person is a litigant in person, by the first listed respondent who is not a litigant in person. Where all the parties are litigants in person, none of them shall, unless the court otherwise directs, be obliged to provide a bundle. But any bundle which they choose to lodge must be prepared and lodged so as to comply with this practice direction. So, in layperson terms, if the applicant, the person making the application to the court, is legally represented, then their solicitor has to do the bundle. However, if the applicant is a litigant in person but the respondent is represented, then the respondent's solicitor must prepare the bundle. If both the applicant and respondent are sensibly litigants in person, realising that you don't need family lawyers, then neither need to prepare the bundle unless directed to do so by the court. Now that opens up an interesting question. Should the court ever direct a litigant in person to prepare a court bundle? And my own personal opinion is absolutely not. It should never be the responsibility of a litigant in person to prepare a bundle for the court. The court should do it themselves. Let me explain my argument. Why would a litigant in person ever know that Practice Directions 27A exists? Why is there an assumption that a litigant in person knows what a bundle is, never mind how to prepare one? Doesn't the court think that the poor family court service users already have enough on their plate without having the stress and worry of preparing and formatting court bundles? A litigant in person who only wants to see their children, juggling the demands of work and living alongside all the trauma of divorce or separation, trying to financially make ends meet whilst perhaps having recently moved out of the family home into unfamiliar new lodgings, their lives dramatically changed, with now the nightmare of having to apply to the family court, who then tells them to prepare the court bundle on behalf of the court. That's simply outrageous. And what about this? Even if they were signposted to Practice Directions 27A, who can reasonably even understand it or follow it? Let's take a look to prove my point. Format of the bundle, paragraph 5.1. Unless the court has specifically directed otherwise, being satisfied that such direction is necessary to enable the proceedings to be disposed of justly, the bundle, if a paper bundle, shall be contained in one A4 size ring binder or lever arch file, limited to no more than 350 sheets of A4 paper and 350 sides of text, and, if an electronic bundle shall be limited to 350 pages of text. Continuing at 5.2. All documents in the bundle, including statements, affidavits, care plans and experts' reports and other reports, shall A. In the case of a paper bundle, be copied on one side of paper only, unless the court has specifically directed otherwise. B. Be divided by the author into numbered paragraphs, and C. Be typed or printed in a font no smaller than 12 points and with 1.5 or double spacing. So what does all that mean? How would a litigant person understand all that? They would need a degree in bundle preparation. So just for fun, let's look at another paragraph from Practice Directions 27A. At paragraph 5.2a.1, unless the court has specifically directed otherwise, being satisfied that such direction is necessary to enable the proceedings to be disposed of justly, and subject to paragraphs 5.2a.2 below, any of the following documents included in the bundle shall be limited to no more than the number of sheets of A4 paper and size of text specified below. Case summary 6. Statement of issues 2. Position statement 3. Chronology 10. Skeleton argument 20. What on earth is that, you may be asking? List of essential reading 1. Witness statement or affidavit exclusive of exhibits 25. Experts or other report 40, including executive summary at the beginning of no more than 4 pages. A care plan 10. Why would you understand what all of that is about? Again, it's outrageous that the family court should ever expect you, as a litigant person, to ever prepare a bundle on behalf of the court. The court should be doing it itself. So, what can you do? Well, if a judge suggests that you, as a litigant person, should prepare a bundle, then perhaps just politely decline and suggest that the court should do it themselves. After all, what's the point of the family court asking you to file your papers with the court if they aren't going to do anything with them? It's their court and it's their court bundle. Explain that you are only the service user. I would suggest that you can also make the point in your position statement, explaining that you are not in a position to prepare the bundle on behalf of the court and that it is an unreasonable expectation. Now, I can't tell you what to do in your case. This is only an option, and indeed at the McKenzie Friends UK network, this is what many of our clients are now doing, and with much success. When we appropriately push back on this issue, the court is actually preparing the bundle on behalf of both parties, where there is no legal representation. So let's conclude on that positive note. And all I am left to do now is to invite you to check out the McKenzie Friends UK network for your one-stop shop for all your family court needs. If you would like a case review with myself, if you would like to find a McKenzie friend, or even to empower yourself with our family court training modules, or perhaps you want to become a McKenzie friend, all you have to do is to visit www.contactphil.co.uk. Until next time.